Ladies and gentlemen, I am SidAlpha, and yes, we're back here yet again. I actually had another video completed and ready to upload when I saw that, as it was announced earlier, that Leonard French, everyone's favorite copyright attorney, has filed his motion to strike Alex Mauer's late response. For those of you that aren't aware of the most recent events, given Mauer's failure to respond, Leonard had filed for a motion for default judgment against Mauer. Mauer, in what seems to be a deliberate attempt to drag out the proceedings and consume as much time and money as possible, filed a response after the 2-month deadline provided by the judge. And due to the nature of the response, Leonard had several avenues in which to combat the late filing, and it would seem that he's grown as tired of all this nonsense as the rest of us have, and is gearing up to give Mauer both barrels from a legal sense, and has filed multiple motions. And as we always tend to do, let's go through them, shall we? And please bear with me, this is a bit of a longer court document than what we're accustomed to in this case. It seems that the time spent by Leonard was put to very productive use. So here we have memorandum in support of plaintiff's motion to strike the answer of Alex Mauer and/or motion for contempt. Plaintiffs filed this action as a last resort. Defendant had ceased performance of her contract for plaintiffs and then began claiming ownership of plaintiff's project, a video game. Don Thacker spent months trying to privately resolve the matter with defendant, yet defendant persisted in making very deliberate public claims regarding ownership of plaintiff's video game. Procedural facts. Plaintiffs filed and served their complaint at the end of June 2017 and quickly amended to correct defendant's name at defendant's request. Defendant was served with the amended complaint on July 7, 2017. Plaintiffs filed a motion for a temporary restraining order on July 11th, after which defendant appeared twice. Defendant fired her attorney after the first appearance and requested time to find one and respond at the second hearing. The court issued an order allowing her to find an attorney by August 21st and requiring her to respond to plaintiff's amended complaint by September 25th. Defendant has filed an untimely response. Plaintiffs have had no contact nor received any correspondence from defendant regarding her attorney or her response until after 3 hours after serving defendant with plaintiff's request for entry of default on September 26th. Even then, plaintiffs only received a copy of correspondence with JP, the court's clerk, informing defendant that she must sign and serve her response pleading. It wasn't until September 27th at 4:50 p.m. local time that defendant finally sent an email to plaintiff's counsel with a signed response. That response was entered on the docket in the morning of September 28th. Defendant's answer is a one-page, single-spaced document. It does not explain the delay in filing the lack of defense counsel. Defendant has failed to show good cause for the delay. Federal Rule of Civil Procedure 6b states in part that when an act may or must be done within a specified time, the court may, for good cause, extend the time with or without motion or notice if the court acts, or if a request is made before the original time or its extension expires, or b, on motion after the time has expired if the party failed to act because of excusable neglect. Defendant has made no such request nor shown any good cause, though defendant had over 60 days to find a replacement attorney if desired and to respond, a requirement. Defendant failed to file any request to the court to extend time and has failed to show the good cause required for such an extension. If the moving party does not seek an extension until after the time limit has expired, the court may exercise its discretion only if a motion is made and the moving party proves its failure to comply with the applicable deadline with the result of excusable neglect. Citing Lujan v. National Wildlife Federation, whether an act or omission qualifies as excusable neglect depends on 3 factors: the danger of prejudice to the opponent, the length of the delay, including whether it was within the reasonable control of the movement, and whether the movement acted in good faith. There is ongoing prejudice and damage to plaintiff, a sincere claimant in genuine need of prompt relief. Development of their video game is currently halted while this action clears up ownership of plaintiff's copyright. The longer this action takes, the later the project development and release schedule, resulting in higher costs and lost sales. The length of the delay is great. After being served with the summons and complaint in the beginning of July, and after hiring, then firing a respected attorney to represent her, defendant requested additional time to prepare a complete and meritorious response. The court generously gave defendant until August 21st, 33 days, to find an attorney and until September 25th, 35 additional days, to file her response. Not only did defendant fail to timely file a response, she also failed to request an extension of time or explain the delay in her response. Defendant has not acted in good faith. Defendant has failed to explain her delay or request court permission for an extension of time. Plaintiff believes and therefore avers that defendant is acting this way out of disrespect for plaintiffs and the courts and with the intention of driving up the costs of litigation and increasing the delay for plaintiffs to move on. The clerk should enter default against defendant. Plaintiffs timely filed a request for entry of default against defendant on September 26, 2017, and served it on defendant 8 minutes later at 12:52 p.m. local time. Plaintiffs' counsel later received email correspondence indicating that defendant attempted to file an unsigned and unserved response with the court's clerk at 3:50 p.m. later that same day. In Yellow Book Sales and Distributing Co. v. White, this court held that a defendant had failed to show good cause for an approximately 4-week delay, where defendant's response made no showing of good cause for the delay. The court recognized that defendant's delay constituted a proper basis for an entry of default under Rule 55A and FRCP 55A. My apologies, ladies and gentlemen. All this legalese takes a little bit to get the mouth to work around. It requires the clerk to enter a default upon motion and affidavit of the plaintiff. Defendant here had appeared and meaningfully participated in the court's hearing on July 13th and July 19th. Defendant fired her attorney after the first hearing and requested time for the court to find new representation and respond. Despite being present and helping set her own deadlines, defendant still did not prepare and file anything with the court until 3 hours after plaintiffs requested and served its entry of default. Plaintiffs speculate that, had it not been for their proper service of the request for default, defendant may not have responded at all. Despite having meaningful face-to-face interactions with the court, defendant was unable to comply even with the relaxed response schedule ordered by the court. Plaintiffs respectfully submit that a strike is a narrowly tailored remedy that can directly address the issue. By requiring defendant to open the default, the court preserves its authority, deters defendant and others from failing to communicate with the court on the matter, grants relief to plaintiffs who have acted in good faith, and requires defendant to show good cause if she intends to challenge the default. In the alternative, a motion for contempt and sanction. Defendant has failed to obey a court order and should be held to show cause why sanctions should not issue. Plaintiff submits the sanction of a strike and default as narrowly tailored remedy. Briefly, the court's inherent contempt powers are broad. Ex parte Robinson. The moment the courts of the United States were called into existence and invested with jurisdiction over any subject, they became possessed of this power, i.e. the contempt power. Defendant has violated the court's July 19, 2017 order requiring her to obtain attorney and respond by September 25th. If the court is unable to strike defendant's answer, then plaintiff requests that the court hold defendant in criminal contempt of court with a remedy of striking her answer and entering default. The criminal contempt standard is appropriate whenever claims or defenses are extinguished by a sanction or remedy. United States v. United Mine Workers, 1947. Title 18 U.S.C. Section 401, the statute codifying the offense of criminal contempt, provides that a court of the United States shall have power to punish by fine or imprisonment at its discretion such contempt of its authority and none other as Section 3, disobedience or resistance to its lawful writ, process, order, rule, decree, or command. Criminal contempt requires the court to hold a hearing where defendant may show cause why they should not be held in contempt. Also, FRCP 11 provides sanction for certain abuses. By presenting to the court a pleading, an unrepresented party certifies that, to the best of the person's knowledge, information, and belief formed after an inquiry reasonable under the circumstances, 1. It is not being presented for any improper purpose such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. The factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigations or discovery, and the denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on belief or a lack of information. And it wouldn't surprise me in the least if I completely lost everyone by now. However, we're almost there. Plaintiffs submit that defendant's late pleading is presented for the improper purpose of causing delay and increasing the costs of litigation. That is, claims and defenses are frivolous and that its factual contentions have no evidentiary support. Plaintiffs respectfully submit that the sanctions of a strike is an exact and narrowly tailored remedy that can directly address the issue of defendant's misconduct. Conclusion: defendant should be required to show good cause for her delay, one way or the other. Regardless of the procedural vehicle the court desires to use, plaintiffs believe that defendant's response is untimely and that defendant lacks good cause for the delay. Plaintiffs respectfully request that the court strike defendant's response and enter default against defendant. So essentially what all of this is Leonard has filed multiple motions to strike, to hold Maurer in contempt, and to require that Maurer explain the delay. And Leonard is stating that there is no good cause and no real provable cause for the delay that Maurer has instigated, aside from deliberately attempting to drive up costs and drag things out as long as she possibly can, which is not a surprise. Maurer actually did state that that was one of her intended goals. That said, this will probably continue on a little bit longer as the court proceedings bear out. But hopefully, these motions, in part or in whole, will be granted by the judge, and then that will be the end of it. I think that we are quickly approaching the finish line, finally. I know a lot of us are looking forward to that date, and while this has been an extremely long reading, my goal here was to get this information up on the screen for everyone to be able to see. And that accomplished, you know what Leonard's next steps are going to be, and now it's up mostly to the judge and Alex Maurer at this point. I think Leonard did a fantastic job here. His filing was well researched, well documented. It really didn't give any wiggle room that an untrained eye like mine would be able to see. It was pretty much concrete. So that said, please do feel free to let me know what you all think about all of this down in the comments below. I know this was a lot of legalese and it was a lot of information, so please do feel free to just backtrack through here, read it at your own pace. And so as I was saying, thanks again for watching. Once again, ladies and gentlemen, I am SidAlpha, and I'll see you next time.